Warm greetings to all. I am Shashank Mishra as a host with the Senior Advocate of Supreme Court of India, Subodh Markandeji. Today we will be continuing from where we left yesterday on topic Law of Prohibition Child Marriage Part 2. The link of the earlier video will be provided in the description box. Sir, you have now to tell us the true implication of orders passed by the Supreme Court in National Commission for Protection of Child Rights versus Golam Deen, where notice has been issued to the Golam Deen and others. An amicus curiae has been appointed to assist the court.
Yes, that special petition arose from the judgment and order of the Punjab and Haryana High Court dated 13th June 2022 in criminal writ petition number 5744 of 2022 called Golam Deen versus State of Punjab. So what happened in that case is that a young Muslim couple who had got married without the parental consent approached the High Court by way of writ petition under Article 226 to enforce their fundamental right to life. They were seeking police protection from probably father against whose wishes they were getting married. So the High Court granted them relief and directed the Superintendent of Pathankot to give police protection to the young couple. So there is nothing wrong in that no one can find fault. That's correct order. What was wrong was the reasoning, and I think that's what the uh, National Commission for Protection of Child Rights has come up against in the Supreme Court. So the crux of the matter is the reasoning given. What was the reasoning? The reasoning was that the wife is 15-year-old. She has attained the age of puberty. And being a Muslim, her marriage solemnized according to the Muslim law is valid. This is wrong because this is wholly contrary to the uh, Prohibition of Child Marriage Act. Once the Child Marriage Act has come into force, there is no question of validity of Muslim law because the age of consent, the age of the bride has to be not less than 15 years. That's the crux of the whole matter. No doubt the High Court was right in citing all that law, which it did, because there were earlier cases which arose in the Punjab and Haryana High Court. So they were Kammu, they were Yusuf Khan, they were Muhammad Shamim, all those three cases. Probably there were a very large number of cases like this. So there was nothing wrong in giving the police protection. What was wrong was the reasoning. And ultimately, I could trace that even that's not the reasoning originally found by the Punjab and Haryana High Court. The reasoning was originally given in two judgments of the Delhi High Court, Muhammad Nihal and Roxana. So that is where this reasoning originated, and that's absolutely wrong. See, the dictum of all these cases runs counter to the law laid down by the Supreme Court. What's the law laid down by the Supreme Court? In Javed versus State of Haryana 2003, 8 SCC 369, the Supreme Court has held that the so-called personal law operates under the authority of legislation and not under religion. This is the reasoning given by the Supreme Court. The personal law operates under the authority of legislation and not under the religion. And it can always be superseded by legislation. Since it is operating under the authority of the legislation, it can always be superseded uh, by the by the successive legislation.
Yes,
So
sir.
law enacted by the legislation, that is statute law, will always prevail over what is the so-called personal law. This is what has been held in Javed versus Haryana. The second thing that has been held is that what the constitution protects is religious faith and belief. So mark these words, religious faith and belief, and not the religious practices. The religious practices do not prevail when they run counter to the public order, morality, health, or policy of social welfare. So this has been held in that famous Shahbanu's case, and it has been held, like it's a very old uh, uh, judgment of the Supreme Court called Muhammad Hanif Qureshi versus State of Bihar. That's reported in 1959 SCR 629. There, what had happened that Muhammad Hanif Qureshi claimed fundamental right to religion to sacrifice a cow on Eid. So Supreme Court pointed out that that's not a religious faith or belief. That's not a matter of religious faith or belief. It's only religious practice. Nowhere in the Quran it has been said that you sacrifice a cow. In fact, in Arab countries where the Quran, Holy Quran originated, there are no cows. They sacrifice sheep or goat or whatever. So this law has already been implemented,
Yes, sir.
but I mean not implemented. This law has already been uh, kind of laid down or pronounced. So so actually, Golam Deens and all earlier cases must be deemed to have been overruled by in view of those two judgments of the Supreme Court. The Delhi High Court could not have held those two judgments which I pointed out. Because that's not law. Uh, but now further uh, what you call further case law has come. So the view held by at least as of today, the Ghulam Deen's law is totally untenable against declared law by the Supreme Court. So let us see what is that. In Independent Thought versus Union of India, it's a case reported in AIR 9 2018 Supreme Court, Criminal 229. So this is what the court has held. The child marriage violates children's basic right to health, education, development, and protection. It is also used as a means of trafficking of young girls. Article 21 of the Constitution gives fundamental right to girl child to live a life of dignity. Early marriage takes away the self-esteem and subjects her to sexual abuse. Therefore, law concerning rights of children are traceable to Article 15.3 of the Constitution, and therefore they are special and not general. And provisions of such special legislation must prevail and take precedence over the general laws. Because reasoning given by the Delhi High Court was that Sharia Act passed in 1937 is special law, and that's why it will prevail. So that is wrong because Supreme Court has said that the right, after all, the prohibition of child marriage act is traceable to uh, Article 15.3 of the Constitution, and that is special law, and that will prevail and take precedence over all general laws. So the judgment of in Ghulam Deen's was I would say someone should have questioned since there were and government officers or whatever, whoever appeared for the government did not point out all this. So that is
Yes,
how
sir.
the problem has arisen. Or I would say a very large bulk of case law was there. So each judge was, before which a matter came up like this, they simply relied upon earlier judgments. And that's how Golam Deen. And I think it needs to be overruled because otherwise there is a lot of havoc being caused to the rights of the children. Because what is the aim of protection of Child Marriage Act? Ultimately, it is to protect the rights of children because early marriage has uh, the consequences of early marriage are so many, which are all, enumerated in that case which I said just now, Independent Thought versus Union of India. There, Justice Madan Lokur has considered so many international conventions and so many law commission reports and have came to those conclusions which I just read out, which I just related. So this Gulam Din's judgment as it is very untenable. In this connection, it would be good for me to say that at least one high court in India took a view contrary to Gulam Din. And there, at least those cases, the original cases which originated in Delhi High Court, they were cited and court said, I don't think this is good law. So the High Court of Madras in Abdul Khader versus K. Pachiammal, she was, that child law uh, prohibition officer in state of Tamil Nadu, and she performed her duty of bringing, some marriages which were taking place, in which the girl was, the girls were, they were, the girls were still minor. They were below the age of 18 years. So there, the Madras High Court held that uh, what had happened there was that the marriage officer, that child marriage prohibition officer, uh, Miss Pachiammal, she went to the court and obtained uh, injunctions in a very large number of cases because that was a batch case. A huge batch was there. So the court issued several injunctions in so many cases. All of them came up in criminal revision before the Madras High Court. So,
Yes, sir.
dismissing all the revisions, the Madras High Court held that religious practice of child marriage, even if sanctified by Shariat Act of 37, runs counter to the social objective set out in the Prohibition of Child Marriage Act 2006 of preventing the evil practice of child marriage. And therefore, those those practices, even if sanctified by Sharia, can't prevail. So, all in all, this was a fit case for the consideration of the Supreme Court, and we should keep an eye on the final authoritative decision of the Supreme Court.
Yes, sir. We
Uh,
will be
I
eagerly
just
waiting
want
for
to
that
add
decision,
one
sir.
more thing.
Yes, sir.
That is that, in 2021, a bill has been introduced in the Rajya Sabha for upgrading the uh, age of the the bride
Child.
also. That is to say, now as I pointed out in the earlier episode, the the proposed age, it is still proposed because the matter is still pending before the committee of the parliament. So the age will be same of the minimum age for marriage will be 21 years.
Yes, sir. Yes, sir. We all will be eager to wait the decision of the Supreme Court and see what the final decision is. And thank you, sir, on a detailed discussion of such video. There are two videos. In the first one we have discussed earlier, and this is the second part of it. The first part you can get the link in the description box. And thank you, sir, for the day and all about you told us.
Thank you very much.